I'm wondering if you could speak a little bit about what you've seen, where you think we're at, and quite frankly, where you think we're gonna be going in the near term.
Big picture, I think the legal sector is going through 3 stages. The first stage I call the stage of denial, and that's when we, as the legal community, have collectively essentially denied that change is necessary or appropriate. It's interesting, the work you referred to that I did with my son, Daniel, when we wrote the book called The Future of the Professions. It's a characteristic of all professions that they think all other professions should change other than their own. And so we suffer a little from that. But in all honesty, I think we're at the end of that stage. It's rare that I meet a senior lawyer who is thinking that legal practice will somehow go back to 2004, who's thinking that the technology is somehow not relevant for them. I think most people recognize that substantial change is afoot. And so it seems to me we're at the second stage, and other people are ahead of the game, but the second stage for the mainstream is what I call resourcing. And from now until the early 20s, I think the dominant theme will actually be, and it doesn't sound that adventurous, but it's using, if you'll forgive me, cheaper people to do legal work. And we're seeing a whole bundle of trends: outsourcing, offshoring, subcontracting, the setting up of low-cost legal resource centers and so forth. But fundamentally, and often it's involving paralegals, the idea here is, let's take some of the cost out of legal service. That's a great aim, but we can do it essentially by lowering our operating costs, our employment costs, our property costs. But and that's the second stage. In a sense, it's if you think there's 2 ways of changing in law, one is using cheaper people and the other is using technology, to some extent, and many people in this room are exceptions, but in the mainstream, the use of technology looks pretty scary and more distant, and that'll be the third phase. And that's the phase I call, or the stage of disruption, where technologies will begin to take on more and more of the tasks that historically we thought could only be undertaken by intelligent human lawyers. And one of the running themes of my work is that our machines are becoming increasingly capable. You can talk about artificial intelligence, you can talk about machine learning, you can use any phrase that you want, but the reality is there's no finishing line apparently here. No one in Silicon Valley is dusting their hands off and saying, job done. Let's call it a day with technology. The pace of change is accelerating, and every day, it seems, we're hearing of a new app, a new system, a new development. And this will, in my view, fundamentally affect the practice of law in the 20s. We're already seeing early signs, but I think we shouldn't overstate. So when we talk about AI, I think a lot of the hype just now is unhelpfully overstating the short-term impact, but it is underestimating the long-term influence of these technologies.
It seems like a lot of what you're talking about right now has to do with supply and demand.
Yes.
It doesn't seem as though there's any lack of demand. And interestingly enough, the law schools continue to graduate more and more students, although in recent years, it seems as there's been a little bit of a decline. How do you see us getting to a better balance between supply and demand, where we have these many law students coming out not able to find jobs, and yet we have an insatiable need for more legal services?
Yes. Can I talk about the book a little bit? It's not a sell because they're getting it free, but very kindly, CLOC have secured, and with sponsorship that's you might want to say a word about the sponsors, it's much appreciated. But we're publishing today, essentially, the second edition of my book called Tomorrow's Lawyers. And Tomorrow's Lawyers was a book I wrote in 2013, and so much has changed in just that 3 or 4 years that I was getting slightly embarrassed by the content, and I felt I needed to update it. But it's an indication of how quickly we're moving on. Now, originally, the book was designed and meant for young lawyers, aspiring lawyers, prospective lawyers. But it turns out that older lawyers like cheap and short books as well. So I've had another go at it, and you've got it before you. But one of the fundamental questions we're asking in there is, what are we training young lawyers to become? And my short answer to that is our law schools, by and large, around the world, are training our young lawyers to become 20th century lawyers rather than 21st century lawyers. Very interesting question I ask many law schools when I visit. How often have you had a talk from a general counsel or someone from an in-house legal department? And the answer is often never. If you contrast that with medicine, if you're in a 5-year medical course, by the 3rd year, you'll be doing more clinical work than classroom work. And somehow many law students can go through a whole degree without even hearing from a client. And I think it's time for the profession, the practicing profession, in-house lawyers and people in law firms, to be influencing and shaping the thinking of the law schools to make sure we're drilling out 21st century lawyers. But these are going to be very different beasts indeed. I'm often rather saddened when I speak to young lawyers. They have a kind of Rumple of the Bailey, John Grisham, Suits, The Good Wife conception. And I love them all, actually, I should say. But they have that conception of legal practice. And it bears very little relation to what is being discussed in this conference over these next few days. And so any law students sitting in here would be surprised at the disconnect between what they're learning and what they're hearing leading clients are actually wanting. And what I've been trying to think about, and Daniel and I did a lot of work in this generally, is what will lawyers be doing in the 20s? And despite what I'm saying about machines becoming increasingly capable, I don't think the 20s will be the decade of unemployment. I think it'll be the decade of redeployment. A good starting point here is one of the big four firms recently said, or their global head of tax said, that by 2020, he wanted at least 25% of their tax specialists to be technologists. Now, why would he say that? Well, it's pretty clear that most large international organizations, when they're looking for tax solutions, whether for compliance or planning, will be expecting these solutions, at least in part, to be technology-based. But if you say we only provide a human service, that's opening the door to other competitors coming in and dominating the technology part. And so it's very clear that the big four, in tax at least, are saying we're going to be the market leaders in technology too. And I think the same argument applies in law, that we can increasingly see, whether it be undertaking due diligence, document review and litigation, drafting of documents, contract lifecycle management, rudimentary legal research, the list goes on and on. We're seeing increasingly that there are technology tools that, if not yet quite replacing, playing at least a very strong role and an important part in taking out some of the costs, which I know is still tremendously important. So that means that what will be important, I think, as for the big four, is that in law firms and in-house legal departments, we have technologists, legal technologists. I don't mean hobbyists, I don't mean dilettantes, I mean people who are genuinely schooled and trained in both fields. And so I think in the 20s, we'll see a whole bundle of other people that we will call lawyers, but they won't look much like the lawyers of today. There'll be people involved with legal process analysis, legal project management, legal knowledge engineering, legal systems design, and so forth. And what I've tried to do in this book is upgrade the skills that I think young lawyers will need to have in the future. So I want to resist the suggestion that there'll be nothing for lawyers to do full stop. There'll be nothing for lawyers to do, or much less for lawyers to do, if they practice as 20th century lawyers. But at least through the 20s, there's going to be so much work to be done in designing and developing and putting in place these systems. And I believe that's the new job for lawyers. And I think it's the same in medicine and in tax and audit and all these other professions too. So just to, if I may, just to finish this point, I often say that the only career decision you need to make as a lawyer and the only strategy decision you need to make if you're in the commercial world for the 20s, is do you want to compete with machines or build the machines? And by competing with the machines, what I'm saying is you say, I want to be involved in the kind of legal practice where I don't really think machines can ever compete with me. It still requires the empathy, the creativity, or the judgment of the human lawyer. And I'm not disrespecting that view, but I think on any view, if machines are becoming increasingly capable, even if the pie is getting slightly bigger, that slice of the cake is reducing. So if you can't compete with the machines, you don't just go unemployed. You say, actually, the joy, the excitement, the opportunity is to build the machines. We want to build the systems, surely our generation, that redefine the way that law is practiced, that enable our businesses to manage their legal and compliance challenges far more effectively, to exploit the opportunities available to them using these new techniques. So for those who think it's a pessimistic view, it's only a pessimistic view you're not prepared to change. And I don't see why lawyers shouldn't be prepared to change when I'm seeing, we looked at 8 professions, and other than the clergy, we're the most conservative in my experience. And I think it's not a good thing to be compared unfavorably with accountants, but if you look at the accountants, and not just Big Four, the professional bodies, small firms as well, they're pressing ahead in building the new systems, and I think that's what we need to do too. Sorry, long answer.
No, it's a great answer, and it leads me to ask the question. So it seems relatively clear the importance of technology, and there are definitely some law schools that are embracing that. There's some at the leading edge, but it seems that the vast majority of them are not. And the law firms are definitely moving in the right direction, but are also rather slow. And you consult with many of them. What are you seeing in what's holding them back, and how do we move them forward? How do we drive change?
I always have to qualify anything I say about law firms and the ones I work with, and I work with a handful of leading firms, but in a way I don't get out much because I only see the ones that want to speak to me. So if I say, for example, that I've addressed maybe, I don't know, half of the top 100 law firms in the world, their partners' conferences, the more interesting question is, what are the 50? That almost certainly means that the 50 who haven't instructed me, none of them in the last 5 years have had technology or fundamental change on their agenda. So what I give you is a rather one-sided view. And I often make the observation, and I may be criticizing some people in the audience here, but I don't think I've ever yet met an innovative law firm in the sense that every partner in the firm buys into this change. The most innovative firms tend to be the ones today where the leadership team are driving the innovation, or you have 2 or 3 very strong, compelling individuals who deliver evidence. And I'd be interested in Larry's view, who apparently gave a great workshop yesterday, but it seems to me psychologically, lawyers are far more driven by evidence than by argument. You can sit down and say to lawyers until you're blue in the face, here's the change that's necessary, here are the patterns in the marketplace, here's what the competition's do, here's what clients are asking for. But for every well-articulated argument, and this is what we're trained to do as lawyers, there's a compelling counter-argument. What we need is evidence. And the most successful law firms are those that actually just get on with it. They stop talking about it, and actually they start experimenting. And it's very much in the R&D spirit that we perhaps see in the consumer electronics or the pharmaceutical industry, where these businesses don't know where their income's coming from in 5 years' time. They probably haven't developed the products that will be delivering their incomes in 5 years' time, so they engage in R&D. And we're increasingly seeing a small number of firms doing that, and I think it begins to make a difference. But by and large, and this is one of my common lines, with prosperous firms, I always say it's hard to convince a room full of millionaires that they've got their business model wrong. These are often very successful individuals who've got a few years to run, and I and others stand up and say this change is impending. And I think many would hope they can hold out to retirement before all this stuff happens. So there's 2 battles there. That one, that people are really, it's not just the conservatism, it's just that they feel that people in leadership positions, that it's their responsibility to deliver the firm safely to the next generation. And that creates a kind of conservatism, a kind of lack of urgency. And the second point is that in many ways law firms are often driven less by obtaining competitive advantage and more by avoiding competitive disadvantage. That's to say, you can worry a law firm more by saying, you're behind your competitors than saying, here's fantastic opportunities. Because if you're already trading successfully, you haven't got the motivation perhaps to change. So I think until and unless the market, ladies and gentlemen, yourselves, puts considerable pressure, you're not going to move beyond what is often tokenism in law firms, where a lot of the innovation is actually on the edge and it's fairly piecemeal. You're not going to get thoroughgoing innovation until there's constant, relentless, informed, discerning demand from the market. And that's what's so important about this group, that you speak not just as individuals, but collectively, because it does seem to me that there are many ways in which we can radically improve legal services, but as long as there's limited competition, law firms are going to continue practicing as they've always done. And that does bring in another issue, but the new competitors in the marketplace are going to be a very significant driver.
Do you see the intermediate or long-term market for law firms trending towards a model that we see among accounting firms? I mean, there's a lot of talk about consolidation. We got sort of the AmLaw 50. I was reading an article recently that maybe what we should be talking about is an AmLaw 12 or 20. Yeah. Is it your sense that that's where the market is going? There'll be more and more consolidation?
I think there will be a lot of consolidation. But when you think about it, one old law firm merging with another old law firm becomes one bigger old law firm. And I can see that gives a sense of change, but it's not the change that I and others would want. I think what rather than go for consolidation and trying to attain greater mass, I think what we're interested in is new service delivery models, new ways of working. One of the dilemmas I often say for the law firm, and it's true of the legal department as well, is that you can't change the wheel in a moving car.
Right.
You've got so much to do. I mean, everyone here, you'll hopefully be inspired by the few days of the conference, then you go back to your office and there's just so much on. And I think the answer to the question, how do you change the wheel in a moving car, is actually you set up a new vehicle. And so I think I say to law firms, perhaps rather than looking for a merger partner, your major development should be setting up a new vehicle, which interestingly in the UK is easier in a way to do because we can set that up as an alternative business structure that's regulated differently, that can perhaps be financed differently, can be managed in a different way. But I think that's going to be the answer.
It seems that a lot of the larger firms are in a rush to grow.
So can I just say, to answer your question, I don't think there'll be consolidation. The big four are unbelievable in size. Deloitte spent more last year on training than the fee income of the largest law firm in the world. The big four accounting firms together, their fee income is the same as the GDP of the 59th largest country in the world. They're of a different order of size. I think we'll see far larger law firms, but I think we've seen over the last 40 years that one of the unique business case studies, the evolution of these businesses. The only qualification I would make to that, well, two. One, there's a chance, and this would be a fundamental change, there's a chance largely because of European developments that at some stage the audit parts of the big four practice will need to split away. If they do that, that opens the way to very interesting...
I'm sorry, why would that be?
Because there's increasingly the regulation. Auditors have always been although they've been in the driving seat, they've often been really the odd man out in the law firm. They cause innumerable conflicts and increasing regulation. You've had Starbucks for years here, but there's a whole new slew of regulations in Europe. They'll make it increasingly hard for these firms to do any kind of work for their audit clients other than audit work. So there's a possibility, and we put in our book as a 25% possibility, but even then it's huge, that these audit firms, that the audit practice could break off. That would open the door to multinational and multidisciplinary mergers between law firms and consulting practices and tax practices, and that would be a different ballgame altogether. So we might see that as a possibility.
In the near term in the UK?
Yes. Well, starting in the UK, I think, but Europe pretty quickly, and I think would have. I know the US regulatory position is different, but I think the commercial imperatives to change would be quite strong.
Historically, the US has been more on the cutting edge in terms of free markets, but it strikes me, and we've been kind of dancing around the issue of, I mean, so much dancing around, but talking about, in part, the opportunities and some of the challenges associated with ABS, alternative business structures. In the US, that's clearly continuing to be a driving force in why law firms are structured the way they are and how they conduct business. It's hard to invest a lot of money in a completely different business model when at the end of every year you've got to basically go to ground zero. So if you could give us your thoughts on sort of ABS, how that's played out in the UK, what you see for the US, and is this ultimately going to be a huge competitive disadvantage for the US? Some thoughts
I do think so, but just taking a step back, interesting you use the term free market, when in a sense it's the opposite. I mean, what Daniel and I study in our book, that's the book, The Future of the Professions, not the one before you, but why do we have the professions at all? And historically, we've given exclusive rights to certain occupational groups to carry on certain kinds of work. The dominant justification, work to the exclusion of all others, the dominant justification being it's in the interest of clients, they need protected. And what happened in England is that a man, not a lawyer, called Clementi, David Clementi was responding to allegations that the UK legal market at least was anti-competitive. There wasn't sufficient choice available for clients, that it was informally a little bit of a cartel. And he, through this work in the early 2000s, started putting forward the argument that greater choice would be appropriate. Not only that, there were many areas of legal work that didn't really need the protection that the classic, what we call the grand bargain, afforded. And the philosophical point is, it seems to me that we should survive and thrive as a profession in law because we bring and add value that no one else can, not because we pull up the drawbridge and don't allow others in. And I've been outspoken about this in relation to the US. You've had various iterations of trying to look at liberalization. But so many of the submissions and the arguments, for example, that only lawyers can attain a certain level of ethical performance, that's inconsistent with what I see in terms of ethics in other professions, that only lawyers have the intellect, the ability, and so forth. These arguments, they're almost laughable for non-lawyers, and it seems to me it's a rather basic form of protectionism. Now, I understand that apparently for political reasons, although as I've traveled the country and spoken to innumerable bar associations who would like to liberalize, apparently on a federal basis, the political forces are such that it's very unlikely that you would liberalize in the short term. Now, just a couple of things. In England, our liberalization is not deregulation. It doesn't mean these new alternative business structures are regulated. They're just regulated in different ways. So it's not a free-for-all. So that's point number one. So the citizen, the client, the consumer is still protected, but by a body of rules that's appropriate, often for fairly low-value everyday law. We have a far narrower conception of what you call the unauthorized practice of law. We call reserved legal business. We've got a far narrower conception of that anyway. But in our liberal regime, what you've seen is, and I admit it's early days, but an influx of new ideas, new thinking, new technologies, new people, new entrepreneurial spirit. And I'll mention, because he's in the audience, you take someone like Carl Chapman in Riverview, he's contributing hugely to the legal profession and challenging and changing the way people are thinking. That wouldn't have happened without this shift. But the bigger point is this: if I'm right, and that the only way in the long term through the 20s for law firms to succeed is by building a new vehicle, US law firms are going to be at a competitive disadvantage because they'll have to fund these vehicles themselves, whereas in the UK, we can set up these vehicles and use external funding. Now, it seems to me if I was in your shoes and I'm looking at the global delivery of legal services, and in the early 20s, we're seeing British-based ABSs allied to law firms delivering legal services at greatly reduced costs at very high quality, doing everything the CLOC's all about, and the US law firms are saying we can't do it because we can't afford it. That's an argument against liberalization. That's an argument for liberalization. So my view is, in the 20s, you, the market, will actually encourage and require a liberalization so that we can, as almost every other industry needs to, have sufficient investment and flexibility in building new forms of legal businesses. Because otherwise, what you're doing is you're squeezing all these new business models into the old partnership ethos, structure, method of financing and management.
Are the LSOs, are the Riverviews, the Elevates, the Integrions, and those firms of the world, are they basically in a position to take that leap? I mean, you suggested a moment ago that the law firms, are merging one old law firm with another one. So is the future here really players somewhat outside the core players, the ones that are positioned to say, okay, we're going to completely change the game. We're going to start in a particular sphere and we'll wait for our opportunity and then move out? Or is it going to come from a different angle?
It's interesting to see how it happened. Now, you mentioned Elevate, and Liam's in the audience as well. Liam Brown, he's another individual. Liam and Carl are quite similar. Having conversations with them is not like having a conversation with a managing partner of a successful law firm. The managing partner of a successful law firm, by and large, is wanting to know what's the minimum amount we can change to keep clients happy, whereas these guys are thinking, how can we fundamentally change the model? And starting almost with a blank sheet of paper. It's a different premise altogether. In the end, whether or not the real disruption and commercial success is enjoyed by the new players or enjoyed by the incumbents is an unknown question. It's unknown over various industries. I can predict fairly confidently, as we've seen over the last few years, that quite a lot of substantial law firms will fade away. I don't think there's any question about that. But I look at other firms, and one of my clients, for example, Allen and Overy, and they're doing a huge amount of innovation, and there's no way they're going anywhere. They're going with that's to say they're not fading. They're going with the disruption. So I think we'll see a blend of the new legal businesses with the traditional legal businesses that are prepared fundamentally to change. And then you've got the big four coming back into the legal marketplace who will deliver legal services in new ways in their own right, but they'll also, it seems to me, it's very likely they'll acquire and merge with some of the other businesses coming through. So the landscape's going to shift. And for law firms to succeed, it's going to require not this quiet nod or lip service to innovation is going to require very fundamental rethinking. And I have to stress, this is not over the next couple of years. This is into the 20s. The next couple of years will be dominated in most law firms by the cheaper people model. It's once we get into the 20s, the real disruption will take place.
I get the sense in talking with a lot of the firms that corporations use that they're quite ready for change from an ABS perspective. Are we at a point where the corporations and the law firms really need to start thinking about trying to bifurcate this market and leaving a lot of the ABS/unauthorized practice of law issues in place to protect consumers? My sense is that there is much greater an opportunity for overreaching with respect to the individual as opposed to corporations that are more than capable of protecting themselves. Is there an opportunity for the industry here to really bifurcate this market and go to the regulatory bodies and say, look, leave those in place there, but for us, let's change the rules and open up the playing field? Because let me just finish this thought. It seems to me, and I'm not an expert in this area by any stretch, but a lot of the protectionism that takes place, at least in the US, is a result of smaller firms wanting to maintain their position, whereas the bigger players are more than capable of rolling up their sleeves. And
I think it's a great point, a very powerful point. In fact, there were a group about probably 4 or 5 years ago, a group of leading, I think it was about the top 20 law firms in the UK, went to the regulators and made precisely that argument in every aspect, and it was rejected. I can see there's difficulties of gray areas between the two, but I'm always struck by, we may say they're in the legal business, but the difference between a large multinational law firm and a sole practitioner, it's so radical as to be laughable that we have broadly the same regulatory structure governing both. Now, whether or not you want to make it as radical as a bifurcation and entirely different regimes, I'm not sure. But I think your point is well made, that we could say that if your major justification for not liberalizing is to do with the protection of the clients, you'd say, on any view, major in-house legal departments of corporations are informed clients, and they don't need the same protection. And I think that's something that most of you would be willing to concede if the corresponding reduction in costs, more business-like service, and all the other things that CLOC is aspiring to could be delivered. So I think it's a strong argument. It's the kind of argument that legislators and regulators can almost not live with because they can't see how structurally it would work. So I'm with you in principle and policy, but I could see that as an issue as a can kicked down the road interminably.
You're a big proponent of online courts.
Yes.
Can you talk to us a little bit about what your vision for that is? And you work with the courts and judges in the UK. Where is that headed?
So this is quite a long story in the sense that I started thinking about this in the early 80s and started really trying to encourage courts to use technology. I think to understand the direction of this, one has to bear in mind the fundamental distinction, two uses of technology, what I call automation and innovation. And automation is when you use technology to streamline and improve how you work today. Innovation is when you use technology to allow you to do things that previously weren't possible. Now, most of the investment in court technology has been so far has been in automation. How can we present documents more helpfully in the courtroom? How can we file them into the system more efficiently? How can we allow judges to manage the documents, search through the documents? But none of this fundamentally changing the model. This technology, in the words that Daniel and I use, is reassuringly familiar. It's turbocharging the current model. So one of the things I've been thinking about over the years is, well, imagine if we didn't use technology simply to optimize and streamline the way of working. Imagine if we tried to use technology to deliver a different kind of service. And I had the opportunity to pursue this in 2014. I was approached by essentially the judiciary in England with the support of the government in the shape of something called the Civil Justice Council. And they asked me to lead a group to look into the potential for online dispute resolution for our low-value claims. And I said earlier, just now, for a self-represented litigant to go through the court system, it's unaffordable, it's interminable, it's unintelligible. And it's so low-tech as not to be imaginable. One of our top judges put it rather better. He says that any system that's got a 2,000-page user manual has got a problem, and that's our civil procedure rules. And so I put together this team of people, and really a great team, some experts, people who have written doctorates in online dispute resolution, quite a few representative people, people from barristers, solicitors, and so forth. And we come up with this idea, and it's published online in 2015 in February, of the online court. And the online court, our conception of it was essentially a three-tier court. At the bottom tier is judges, and it's proper trained judges, deciding cases, but not in a physical courtroom, deciding cases on the papers alone, and maybe with a bit of video call or telephone call, but basically the kind of cases where the judge can make a reliable decision, a low-value case, by just looking at the papers alone. That would be in the bottom tier. Because we asked the question, is court a service or a place? Do you really need physically to congregate to resolve all problems? We thought not. But we also said, wouldn't it be useful, because a lot of the cases that reach judges, many judges say, how on earth did this get through the system? Because I'm afraid often lawyers escalate disputes. So wouldn't it be good if we had a tier that helped contain the problem? And with the idea of, the government's now calling it case officers, we're calling them facilitators, but people who could look at legal cases before the judges see them and maybe knock the parties' heads together and say, look, guys, this just doesn't make sense. It's in no one's interest. 95% of these cases are decided in this way, or what are you really after, so forth, in the spirit of alternative dispute resolution. But before we got there, we thought a top tier, surely what our court should be doing, and our government, our state should be doing, is providing online legal help so people can understand their legal entitlements and at least understand the options available to them. So we rolled all these three tiers together. We called it the online court. And frankly, having recommended stuff for 30 years, I thought it wasn't going to go anywhere. But I was really quite determined with this. Our current Lord Chief Justice is the most amazing man. He's retiring later in the year, and I will say now, he's the most remarkable person I've ever worked with. He's quite phenomenal. But he was so supportive in all of this and helped us drive it through. And so later in the year, he gave a public speech endorsing it. Our Secretary of State, for Justice, the next day endorsed it. And then amazingly, in the end of 2015, the government announced they were going to spend or invest £738 million in modernising and digitising our courts. After that, a very senior judge did a review of our civil system, endorsed our model, and it's all going through. I mean, our election has caused a problem because we had a piece of primary legislation called the Prisons and Courts Bill that was actually essentially introducing online courts. So it's actually in the back burner while we have the small issue of trying to elect another government. But it's been a great lesson for me in a couple of ways. One is that at a certain stage, and I think this is relevant for everyone in the room, we've got to stop talking about these things, you've got to start doing it. You've got to start, it's the movement towards being an activist rather than just an armchair theorist. And although I fall into the trap and I talk about disruption and all the rest of it, almost every day we're reading people writing the same article. Laws in for great change, technology is going to have huge impact, clients are increasingly demanding. We don't need any more articles on the subject. We actually need action. We need people to get together in working parties and starting designing systems, protocols, procedures, changing practice. And I think that's the next stage of what is essentially a movement. And that came through with our work. That if I'd simply written a book called Online Courts, people said, oh, that's very interesting and nothing would happen. You need to engage as an activist. You need to create some sense of urgency. You need to build, as change theorists would say, a coalition of people backing it, and you'd relentlessly to drive it through. So our next thing is in July, and if anyone can come, they're more than welcome. We're holding a 24-hour hackathon for online courts. We've got about 10 quite tricky problems to sort out in how the online courts actually work. But rather than leaving that to a small group of officials and judges, we're opening it out to the whole legal community. And we just announced it 2 days ago, we get great sign-up.
That's great.
So events like this, our hackathons, it's in the spirit, and it might sound too radical, but it's in the spirit of a movement. Because if you're passive, if you wait for suppliers who are broadly happy to change, you're going to be waiting a long time.
A couple of quick announcements I'd like to move to as we kind of start to wrap it up here. We've got 2 microphones here, so for those of you that would like to ask some questions, Professor Susskind, please feel free to come forward. I'd like to reserve at least a few minutes for that. And also, Professor Susskind will be in the exhibit hall this afternoon, available to sign books. Unfortunately, we're going to lose his presence at the end of the day. He's got to travel back home, but for the time that he's here, I'm sure that he's going to be more than willing to answer some questions.
More than happy.
But please.
Really quick one. My daughter's about to start at a magic.
You're going to have to speak up a bit there.
Is it really? Okay.
Not that loudly.
Right, my daughter's about to start at a magic circle firm, just doing law school.
Congratulations.
It's Lauter and May. Well, I don't know. She followed her mum and dad into law. But what would you advise her to do? She's about to do 2 years training. What would you say to her?
Well, I mean, first of all, just as an interesting side comment, when I do research with in-house lawyers, I often ask them which law firm do they think is the best law firm in England, and 50% of them say Slaughter and May. So genuinely, congratulations to your daughter. And they are probably one of a very small number of firms for whom change may not be so fundamental. And I think it's a far smaller number of firms than many firms would like to believe, but there are 1 or 2 in every jurisdiction whose value is so great, who can probably live by bespoke work alone. The thing I say in the book is if you can get a training contract, please at this stage still qualify as a lawyer. That's terribly important. If your child really does, did you say daughter or son?
Daughter.
If your daughter really thrives at Slaughter and May, that's probably the best. That's probably the best firm in the country to compete with machines. You know what I was saying about competing with machines. But I suppose there's a bigger question that I ask everyone who's going into law, and that's to say, at this time of greater and more rapid technological progress than we've ever seen, one of the great privileges, I think, for young lawyers is you don't just need to take the baton from the people in the year ahead. You don't just need to do as it's been done in the past. For me, I think the great excitement, the opportunity is to be one of the architects, one of the activists, one of the people who's involved in this period of legal reform. And so, of course, someone who's successful in Slaughter and May will probably have a great career for a decade or 2 yet. But isn't it a little bit to miss an opportunity to be involved in redefining how the law is practiced and how justice is administered? So in the end, it's an individual choice for your daughter in particular. I think she can successfully compete with machines. But the bigger question is whether or not she should want to.
Any other questions? So Professor Susskind, I'd like to believe that this... Oh, wonderful, please.
So what would be your recommendations for solo practitioners, especially given that they probably will not have the capabilities of the big law firms to get AI training and technical training? So how should they service corporations and their clients, individual clients? Thanks.
So practitioners, there's a bit in the new book about this, because in the first edition of the book, I possibly too dismissively said, I still think this, but it was too dismissive, saying that I find it hard to see how sole practitioners will survive in the 20s unless they fundamentally change. I still think that, but I write at greater length now to explain why I think that, and the questions one needs to ask oneself. And it's really a little bit like the difference between the corner shop and the major store. There certainly are characteristics of the corner shop that bring our customers there, that the highly interactive personal service, the convenience. There's a whole bundle of things one can identify. And so one has to really ask the fundamental strategic question, is there value I can add as an individual, based probably in relationships, based probably in the nature of me as a service provider, is there sufficient value that I can add that will keep people coming back to me and not going to the major store? And I think that's quite a tall order. So my view is that only very few sole practitioners, in the same sense as only very few craftspeople, carpenters, hand make furniture anymore. A few will survive, but most will have to change. Now, on the face of it, you might think, well, the most attractive and interesting way to change is this for a whole bundle of sole practitioners to get together. But actually, small and medium-sized firms are under pressure as well. So I think you might want to do something more imaginative. I think you get together with other disciplines. I think there is room for a different kind of corner shop that's actually a more multidisciplinary practice. Because if you recognize, often it will be the interpersonal skills, the empathy, the relationships that's bringing people to you. This is a terribly sexist phrase we used to use in Scotland. The lawyer used to be called the man of affairs, and that was the person who didn't just do the legal work, looked after all your business interests. So a commercial advisor, an accountant, a tax specialist, and so forth. But I think we could simulate that as a physical offering. The second thing is to say that there are countless examples of very successful online services that are delivered by very small organizations. So maybe the answer is not to think, how do we continue to grow as a traditional practice, but how might we provide some kind of online virtual service? And there's a lady in, just as a case study very quickly, there's a lady in England called Tessa Shepperson, and I always quote her. She's a property lawyer, and she set up an online community for people. At one stage, the early case study was people who'd bought second homes to rent out for extra income, who couldn't really afford heavy-hitting property lawyers but needed access to some kind of legal advice. And she set up this little community where you get access to lots of useful information for something like, I don't know, it was £100 a year. And then she had about 1,000 people subscribing to that. And then when any of them actually had difficulties, they went to her. Presto, she's got a great business going. And you can't replicate that across all areas, but sole practitioners shouldn't fall into the trap of thinking I need to be a multinational to afford the technology. A lot of the technology is off the shelf and quite affordable now. Thank you.
I think we're almost at time, but I'd like to leave you with one last question.
Sure.
And that is, I'd like to believe that this room is full of activists. And members of CLOC, people in legal operations, by definition, are leading the charge. They're the pit bulls, as Connie pointed out this morning. And in this room full of activists, there's probably $30 billion, $40 billion worth of spend represented in this room, at least in the corporate services market. Is there a thought or two that you would leave with them to serve as activists and drive specific kinds of change that you think are really going to make a difference in this marketplace?
Just one thought I had, and it's a huge question, but I mean, the nature of the event's very interesting. Just a little example of something that, in my own involvement with conferences, that left a mark. About probably 18 years ago, I was advising Arthur Andersen, the tax practice. And I still, to this day, said it was the best client I've ever had. Being in a room with a group of Andersen tax partners, they were all so punchy, imaginative. It was great. They were really great. And
by the way, that's the first time that anyone said punchy and great about tax accountants.
Yeah, I know. I could see I could see the look of confusion on your face. And I was working with one of the partners, and we were planning his conference. And it was a conference it was about 300 tax practitioners. And they'd lined up an event. It was absolutely not to criticize any events, including this one, a fairly standard event, lots of sessions and so forth. And this guy just suddenly said, because one of the themes of it was knowledge management at this time, and he suddenly said, what a wasted opportunity having these 200 or 300 people in the room and them sitting listening. Why don't we put them to work? So over 3 days, rather than getting them to listen, he actually divided them into groups, and he forewarned them, you're going to be required in the 3 days to work in a group and produce a standard piece of knowledge in this area, standard documents in that area. And so the purpose of the exercise, and you can maybe do that day of this next year, is to produce rather than think and reflect. And this is my point, that at some stage we need to move away from being in violent agreement with one another that change is necessary, to saying, actually, what practical outcomes, what are the 6 things that CLOC could deliver, the 6 products that would reduce that 30 or 40 billion to 25 billion. And then maybe you start off. It's a bit like, I suppose in many ways what I'm saying is you might like to have some mini hackathons, not necessarily technology-based, but the intellectual horsepower in this room and in this building is so considerable that I think one should be moving, as I say, from theorizing and agreeing about the importance of change to collaborating and actually producing.
You couldn't have created a better setup for tomorrow's Big Thinker session on the Magna Carta and the workshop that we're doing tomorrow afternoon, where we're hoping to accomplish maybe just a little bit of that. But let's give a very, very big round of applause.
Thank you. Thank you very much.
Thank you very much. It's been a real pleasure.
Thank you.